We're always smiling.
Hello, welcome to Legal Action. My name is David Siegel. Thanks for joining us. Today we're going to be talking about bankruptcy, Chapter 7 and Chapter 13, which are the two chapters that help people either get out of debt or reorganize their debt under the United States Bankruptcy Code. Joining me as always is my co-host, Jesse Barrientes. Jesse, how are you today?
I'm doing fantastic, Dave. How about you?
Hey, you look like $1 million.
Oh, you too, my friend. It's nice to see you.
I'm trying to keep up with you. It's not easy.
Okay, that's all right.
So
hey,
far I got
right.
the cufflinks.
Got the cufflinks. It's
But I
excellent.
got to worry about the pocket square.
Oh yeah,
and,
you need the American
and the watch,
flag
the
there.
ring, and the flag.
Well,
So
okay, that's okay. Hey,
many items.
We're close.
But anyway, we're not bankrupt right now.
That's true.
And a lot of people, unfortunately, are going through tough times in this country, whether it's credit cards, medical bills, houses that went into foreclosure, vehicles that they couldn't afford, divorce, job loss, illness. There's so many things, but for the grace of God go I,
That's right.
that can bring us down and put us into trouble. But the good news is the government has procedures and methods in place to help those who are honest debtors who need a fresh start or who want to keep property and reorganize and pay. So let's talk about that, Jesse. What is Chapter 7 bankruptcy in a nutshell?
Well, in a nutshell, Chapter 7 is a fresh start. So provided you're eligible for it, what happens is all of your debt gets wiped away. And so it gets you from under that enormous pressure. It is pressure. You know, there's a lot of people that come in and they're robbing Peter to pay Paul. They're doing balance transfers back and forth, one credit card to another credit card and everything else. And, you know, it's difficult, especially if you don't make enough. You've got activities for your kid. You got to take care of things. And a lot of times people, they'll just pay the minimum balance due on their credit card, and that's never, if you pay the minimum balance, that's never going to get you anywhere. Although I believe if you pay double the balance and stop using your credit card, you should be able to pay it off in 3 years.
Yeah. What's good news is under the new law, the credit card companies have to disclose that if you're making the minimum payment, this is how much is going to go towards it, and this is how long it's going to take in terms of time, months or years, to pay it off. So there are disclosures now that put it front and center in people's minds, so they know that.
That's like the truth in lending disclosure for real estate when you're getting a mortgage. They have to tell you, This is what you're borrowing. This is how much you're paying for what you're borrowing if you pay it back during the 30-year term or whatever else.
It's also like the calorie count on a Big Mac or on a Twinkie. If you want it, you're probably going to eat it no matter what that thing says.
That's true, but it's nice to at least so that you can see it and you have an idea. You know, if indeed you actually, like you said, you actually look at it.
Yeah, there are definitely debt warning signs, and one of those debt warning signs is if you're only making the minimum payment on your credit card. So hopefully that disclosure also shows people that, hey, there's a problem here. I have to be careful with credit. I have to be careful about obtaining more credit because I can't make anything more than the minimum on these cards.
Right.
And, you know, 61% of Americans are living paycheck to paycheck. So if something were to happen with their job, either time off, layoff, furlough, whatever it might be, it's going to be impossible to pay that credit card debt.
That's correct. And like you said, I mean, for all those reasons, all the other reasons you mentioned too, why people get into trouble, you know, it's not just, okay, hey, you don't know how to manage money, although that also may be the reason too, when you do something like that. You know, when would somebody be ripe to file a Chapter 7?
Well, Chapter 7 is perfect for someone who is struggling with mostly unsecured debt, credit cards, medical bills, personal loans, past due utilities. If they don't have significant assets, and again, you could have assets. The state of Illinois allows you to protect $15,000 worth of equity in a house, $4,000 worth of miscellaneous property, $2,400 worth of equity in a vehicle, all of your 401k and retirement. So you can keep property in a Chapter 7.
Let me ask you on the side of that, how about things, what if I have a workers' comp case, or what if I have a lawsuit against somebody, be it personal injury or something else?
Well, workers' comp, if you're hurt at the job and you don't have a claim against a manufacturer of a forklift or some kind of equipment.
So a third-party claim.
Right. If you don't have a third-party claim, then 100% of your workers' compensation benefits and settlement are protected under Illinois law and under the bankruptcy law
So,
vis-a-vis.
so if I end up getting $500,000 as a result of my workers' comp claim, that's all mine and whatever payments I get.
It is 100% yours. So you can still get out of debt and keep that workers'
keep
comp
that.
because it's a protected asset under the state of Illinois. As for an injury case, let me tell you this, you're able to protect up to $15,000 worth of equity. So if you have a major personal injury,
Right.
you're only going to be able to protect a certain portion of it. But for a lot of injuries or soft tissue, that amount never exceeds the $15,000.
And so might as well just go ahead and get your debt, which is totaling much more than that, out
Right.
of the way. So if you have somebody, okay, so we're talking about the third-party claim, workers' comp, which is the exclusive remedy for being injured on the job. So that's protected. Again, you said all of your retirement. What if I have a substantial amount of? What if I have over $1 million in retirement?
Well, all of your
assets.
retirement should be protected, provided it's either an IRA, 401k, or other ERISA qualified pension or profit sharing through your employer. The exception would be a naked retirement account. So money that you put into either Fidelity or Vanguard or a bank that's not qualified. If it's just money that you're using like a day trader and you're calling it your retirement, that is not protected
Okay, so
money.
it's got to be an actual retirement account.
Correct.
Okay. What are the pre-filing requirements? You mentioned some of them.
Pre-filing requirements, there's three big ones. The first is you must submit to a credit counseling session.
And what is that like?
That's a 1-hour session that could be done over the telephone or on the computer. The cost going right now is about $15. It really is a complete waste of time. However, it's a requirement that must be completed.
It's a hoop you got to jump through
Absolutely.
before you file.
Before you file.
So what happens if you file my bankruptcy today and I took the test today or took the class today?
You have an invalid filing, which is void. So you'll have to actually dismiss that case and start over. A couple other requirements, very important.
Okay.
1 year of federal tax returns for a Chapter 7, although most trustees are starting to ask for 2, even though the code only requires 1.
But you got if the trustee asks for it, you got to give it to him. Or
That's
her.
true. And then 2 months worth of pay advices or proof of income, whether it be from a job, unemployment, workers' comp, Social Security,
Well, Dave,
disability.
I'm a landscaper, and so I really don't have payment advices, and I'm also a nanny, and I take care of kids. So there's a lot of vocations like that where you don't necessarily have payment advices. What happens in a situation
Well,
like that?
Your attorney can prepare a statement which says just what you said. I don't receive pay advices, I'm paid in cash, or I'm paid in barter, whatever it might be. As long as there's some kind of proof, such as the statement,
Right.
that will suffice. However, if you are getting paid from a regular job, you're going to have to provide those pay advices, because not only does the panel trustee who looks over your case want those, but in many cases the U.S. trustee, which is the boss, the big boss over everybody, also wants to review those to make sure people qualify for Chapter 7 and that they don't have the ability to reorganize under Chapter 13 where they would be repaying a portion of their debt.
Is my employer going to know? I mean, I'm a little leery about giving my payment advices out. I don't want you to contact my employer.
Your employer does not have to know about a bankruptcy filing, with the exception, if you're currently being garnished, once your case is filed, your attorney is going to send a bankruptcy notice, known as an automatic stay, to your employer's payroll to stop the deduction.
So let's talk about that, the automatic stay. So it sounds like a magical kind of thing.
It kind of is.
Okay. And so what does that affect? You mentioned about a garnishment. So what if I have some judgments against me? What if I have some pending litigation?
Great thing about an automatic stay is it stops just about everybody in their tracks. There are some exceptions, child support, criminal proceedings, things like that. But any kind of wage garnishment, any kind of citation to discover assets, any kind of court appearance that's an effort to collect a debt is going to be stayed upon the filing of a Chapter 7.
And certain things, like you said, criminal stuff. How about my tickets? I might have gotten a couple of parking tickets and maybe some tollway violations and maybe a speeding ticket. Is that going to take care of that stuff? It's not criminal.
No, the Chapter 7 stay will technically not apply to moving violations and things like that. You would think it would, but the judges just don't adhere to the bankruptcy laws. They feel that they have an exception, and it's kind of a gray area, so we advise clients to plan on paying your moving violations handle your criminal matters.
Okay.
Because the bankruptcy stay is not going to protect you.
What happens if a creditor doesn't follow I get these calls all the time, right? Actually, I get them on my office number or my cell phone where it says we're looking for this person, and I tried to block the calls, but they still call, and it's we filed a criminal complaint against somebody, and they give the name and call the office, and so what happens after the stay if they continue to harass me that way?
Well, the most important thing is to get notice to that person, whether it's the official notice, which comes from the court, or whether it's your own automatic stay, which you create with the case number and the date of
So your
filing.
attorney can send that, and
Yes.
that's just as good.
Yes, if you get that to them and they continue to contact your client, then you can go back into court on a rule to show cause and try and sanction them for violation of the automatic stay. And then once the case is over, if they keep continuing, then it's a violation of the discharge injunction. So you got a couple different ways. You can either stop them during the case or stop them after the case, but hopefully they stop on their own because your client basically doesn't want to be harassed despite the fact that there's a remedy.
Right. So what type of debts are eliminated then? We obviously the ones that we talked about that aren't.
It's probably better to talk about the ones that don't get eliminated. Student loans, recent taxes, parking tickets, child support, alimony, maintenance, debts for DUI where you hurt somebody, criminal restitution. These are the debts that are going to survive. Fraudulent debts, if you took out money under fraud or false pretenses, that debt won't go away. But the overwhelming majority of debts, Jesse, that people have are medical bills, credit cards, personal loans, payday loans. Attorney's fees sometimes, depending on how litigious they are and what kind of problems they've had over the years. But overwhelmingly, a nice fresh start, eliminating a lot of unnecessary debt that people don't need to carry forward for the rest of their life.
I'm kind of nervous. Am I going to have to go to court for this?
Oh, you're not nervous. You do have to go to court. Not really court. You'll have to go to a meeting of creditors.
What exactly is that?
It's under Section 341 of the Bankruptcy Code, which mandates that the debtor, the person filing, appear before a Chapter 7 trustee to be examined under oath with regard to their income, expenses, assets, and liabilities.
Well, how long does it? So I'm filing a petition, presumably here, right, for bankruptcy.
You are filing a petition, which is about a 65-page document.
Well, doesn't it have all that information in there?
It has all that information.
Isn't it signed under penalty of perjury?
It is signed under penalty of perjury.
So what do you need to? Why do I need them to go in and?
They want to get you face-to-face. They want to get you sworn in. They want to get it recorded. They want to make sure that those for filing for bankruptcy protection are in fact those individuals and that you didn't use somebody else's social and run up debt. And they want to make sure that you don't commit perjury. And if you do, there is a significant area entitled bankruptcy crimes where you can actually be locked up for fraud.
So when I go, they want to make sure I am me, so I need to bring identification, or
That's
what do I
right.
need to bring?
You have to bring your Social Security card or evidence of your Social Security number, as well as a government-issued ID.
So what other evidence would there be of my social if I don't have, I mean, heck, wow, I probably got one when I was a kid.
Some trustees will take a tax return or a tax transcript,
Okay.
some type of benefit statement, maybe a prior tax return. But most people can get their Social Security card or the equivalent of it by going to the Social Security Administration office in Chicago and in many of the suburbs.
Okay. And so you said it's recorded. Now, I know that the folks at home are probably not going to believe this, but the last time I did one of those, a meeting of creditors, it's actually a cassette recorder. Hopefully, yeah.
Yeah, I think it's still a cassette recorder for some of the trustees.
Some
it's
of
just
them
easy.
Some of them are doing electronic.
Some are doing electronic, and in some counties they just record it and they don't transcribe it.
Okay, so you have all that going on. Does it get saved for any particular amount of time?
I think the U.S. Trustee's Office definitely saves these recordings. I'm not sure exactly how long. They usually have 1 year to come back in and reopen a case.
Okay.
Or to vacate a discharge if they find out something. So I think 1 year is about the time frame where the U.S. Trustee's Office wants to preserve all documentation. And after that, I think it's a little bit lessened.
How long does this meeting of creditors take?
The actual meeting, if you have a simple case, will be 5 minutes or so.
Oh.
You may wait for a half hour or an hour to have your case called. but plan on being there for an hour or two, even though your meeting might only be 5 to 10 minutes.
So it's just the trustee, my attorney, and I, nobody else, none of my creditors are going to be there?
Well, your creditors do have an opportunity to appear. However, most creditors understand that a Chapter 7 case is not going to produce any assets or any distribution. So in those cases, they feel it's not necessary. The trustee is going to do his or her job, and if there is an asset discovered, a notice of an asset will go out, and creditors will have an opportunity to file what's known as a proof of claim to be part of the payout.
After they discover whatever that is.
After they discover it, collect it, liquidate it, and leave something for the creditors.
What kind of property, or can I keep anything when I file a Chapter 7 bankruptcy? I mean,
Yes.
you mentioned some things like my retirement, the proceeds from workers' comp, and up to $15,000 of a personal injury claim. Other than those things, what about my house? I mean, man, it's a bummer. I mean, that's the only thing I've been able to keep, level and paid. I mean, I'm not behind on that. So, do I have to leave my house?
Well, the house is important. We have to make sure that the value of the home is accurate. And then we're going to subtract from that value the amount of indebtedness. So if a first mortgage, second mortgage, any kind of judgment liens, IRS liens, that has to be subtracted out of there to determine what your actual equity is. Now recall, you can keep $15,000 worth of equity in a homestead. If it's a joint case, husband and wife, you can keep $30,000.
What if it's not? What if I'm the only one that's filing, but my wife is on the title?
Well, that's even better, because your wife is entitled to 50% of the equity in that case, because she has a marital interest in that property. So you can actually keep a lot of property and still go through the bankruptcy process. But you want to make sure that you're not exceeding the Illinois exemption amounts, because if you get an aggressive trustee, that trustee is going to market the property and try and get something for the creditors, and you will be displaced.
But there's some other considerations like, there's expenses involved for the trustee, isn't there?
There are, especially with real estate. You're looking at a 5 or 6% realtor commission. You're talking about title expenses. You're talking about other expenses related to the sale of the property. And then you have to factor in the tax too. Whatever the trustee is going to recover in terms of assets,
right,
there's a tax return that has to be filed with regard to those. So there has to be something significant to make it worthwhile for the trustee, who also has an interest in getting paid a percentage as well as a fee for being the attorney for the estate.
Okay. Well, okay, so how long does the process take from when I come to your office? Well, let's just say from filing. I've already been to your office. I've given you the things that you've asked me to. I'm here now to sign off on the 60-plus page petition that you told me about, right?
That's right.
And so
you want to get filed now, correct?
You're gonna file it because it's late in the evening. You're gonna file it tomorrow morning. So what's the time frame between the filing and the meeting of creditors and the discharge?
Sure. Once a case is filed, notice is going to go out to the creditors within about 5 to 7 business days. The actual meeting in front of the trustee, the 341 meeting of creditors under the Bankruptcy Code, is going to take place 4 to 6 weeks after the filing. And then after that meeting, the debtor is going to wait a 2-month period, which is where creditors can file objections or adversarial complaints trying to hold particular debt non-dischargeable. Once that deadline runs, that 60-day deadline runs, the case goes to discharge. So from start to finish, filing until discharge, you're looking at about 110 days on average. So really pretty quick.
So like 14 weeks?
Well, a little less than 4 months. Yeah. Not bad. But you're going to feel like you got a fresh start immediately upon filing, because the creditors get noticed. They can't call you anymore. The weight is lifted off your shoulders.
Sure.
You just have to appear at the meeting, take a financial management class for 2 hours online.
Afterwards.
And then get a discharge after.
So what is that about? It's online only?
It's online or in person at some places.
Did you say 2 hours?
2 hours.
You said the other one was an hour.
Yeah. You're going to take a credit counseling session before the case is filed, which takes about an hour to an hour and a half. And then after the case is filed, you're going to have to submit to a 2-hour personal financial management instruction course.
Okay, well, help me out a little bit. What's that about?
The government wants to teach you everything in the world about finances and credit and purchasing a car and insurance. And they're going to cover it all in a 2-hour period.
So I have to take that before I get my discharge?
That's right. And if you fail to take that class, your case will close without a discharge which means you went through the whole process for no benefit whatsoever.
And you can't reopen that up or anything?
You could reopen it up, but there's a $260 filing fee to do that with the court at the time of this airing. There's attorney's fees involved. And really, you're going to get a notice from the court. You're going to get a notice from your attorney. You have to submit. You have to follow these rules. You have to get this done. If you want the fresh start, you're going to do it, Jesse.
Can you give me a range for a simple case, roughly? What is the initial filing fee for Chapter 7?
The filing fee at the time of this airing is $335.
Okay. Well, I mean, that sounds kind of reasonable if I'm going to get rid of $50,000. Okay. Now, what would I expect on the marketplace here for a range for attorney's fees for something like that?
It's definitely going to vary based on the county, based on the complexity of your case, based upon the experience of the attorney that you hire. You could see fees anywhere from $900 all the way up to $2,500 depending on the case.
In addition to that filing fee?
Correct. In addition to the $335 filing fee that has to be paid on any Chapter 7 bankruptcy case in the country.
That goes to the clerk of the bankruptcy court, not to your attorney?
Correct. It goes to the clerk of the court for the privilege of being able to get out of debt.
Well, hey, like I said, if you're getting rid of all this stuff, it sounds like a plan, sounds like a deal. Now, what happens? Okay, so everything's done. I get my discharge. Now I'm starting to feel a little again here, Dave, because I don't think I'm going to be able to get credit.
Well, don't be bummed, because you will be able to get credit. Credit probably faster than you can imagine. Before your case is even over, you're going to get dozens of letters from auto lenders looking to put you back into a vehicle. Now, you got to be careful. Some of those are going to be bad deals, high interest rates, but there will be offers for credit. You can get a secured credit card anytime after filing. That's where you put money in a bank, you start to use the card, you get some benefits and some good credit reporting on that.
Wait. Secured credit card, I put money in the bank, so what I have on the card is what I have in the bank?
That's right.
Well, that doesn't sound like a credit card at all. It's not credit, I already have the money.
Well,
if I wanted to spend my own money, I wouldn't ask for credit card, Dave.
Here's the difference. It reports positively to the bureaus. And then that secured credit card can eventually turn into an unsecured credit card. So it really is a good thing to do.
It sounds like one of those Visa gift cards, Why don't you just charge that up?
Well, look, everybody wants to know how fast can I get out of debt?
Right.
And the very next question is, how soon can I get credit again? And the answer is very soon. You just have to be smart about it.
Is my credit score going to be lousy all the time here? What can I expect with that?
Your credit score will definitely take a hit initially.
Yeah.
However, it will start to rebuild the longer you get away from the bankruptcy filing. But you have to ask yourself, what's your credit situation now?
Well, if it's already bad, it's how much worse can it get then, I guess, right?
Or if you're making all your payments and you have a great score,
yeah,
you're still carrying how much debt on your shoulders. Right. So what good is a good score if you can't do anything with it? So there really is a blend. You have to get out of debt first and then rebuild second.
Okay. Let's switch gears a little bit here. We talked about Chapter 7, which you asked me in the beginning in terms of it being a fresh discharge, a complete discharge. What is a Chapter 13?
13 is a reorganization. That's where you keep all of your property,
okay,
and you repay a certain amount of your debt over time.
So a consolidation.
It is a consolidation. You'll typically see this in a mortgage foreclosure case, or where somebody fell behind on the mortgage and they're not able to get current and make the full payment. They can actually file a 13, start making their regular payment again, and pay the part they fell behind, known as the arrearage, over a 3 to 5 year period.
Well, what else? Why else would I file a Chapter 13 then? Okay, so arrearage on my house, and I want to keep my house.
You might have non-dischargeable debt, such as student loans, child support, priority taxes.
What is that going to do for me if I file on those things?
You can repay it over 3 to 5 years and protect your license.
Oh my goodness! I don't think I'd be able to pay my student loan over a 3 to 5 year period.
Well, you can pay 10%, and then after the case is over, you can pay the other 90 or still owe the other 90. But parking tickets, I failed to mention that. That's a big one. If you don't make payments on parking tickets, your license could be suspended. And then you're driving on a suspended, you're going to get pulled over.
And just a vicious circle back.
You'll be in a 6303, which you're very familiar with, driving on a suspended. Hope they still call it 6303.
Yeah, you're okay, Dave.
Okay, I'm okay on that one?
Yeah,
okay, good. But if you go a Chapter 13 route, while you're in that repayment status for 5 years, your license is protected. You're not going to be suspended, provided you don't incur new parking tickets after the case is filed.
In terms of the Chapter 13, are there any different pre-filing conditions than the ones we talked about for Chapter 7?
There's one difference. You still have to take the credit counseling and provide the paycheck stubs. instead of 1 or 2 years of tax returns, you're required to provide the most recent 4 years of federal tax returns.
What if I didn't file during one of those years?
You need to file. Or if you didn't have to file, you'll have to do a statement that said you didn't need to file. But if you did earn money...
Because I didn't make enough money to file in that year or
Correct.
anything else. Okay, so basically then in Chapter 13, sort of like a consolidation, I pay all of my secured creditors 100% of what I owe them within 3 to 5 years, and my unsecured 10%. So
It depends on the case.
basically I have to have enough money after my allowable expenses to be able to fund the plan, right?
Right, but if you're not making your credit cards, if you're not making the minimum,
Okay,
you should have
that's
something
true.
available.
Or my car payment.
Right. One thing important, you said bill consolidation, debt
Yes.
consolidation. The big difference between Chapter 13 and the debt consolidation you hear advertised on TV and the
Correct.
radio is Chapter 13 has a lot of strength. And by that I mean if creditors don't participate in the repayment plan, they're out. They have to participate or they're out. With debt consolidation, they don't have to participate. 90% of them can, and 10% can decide, no, we're going to sue, we're going to garnish.
And then you're out of luck with respect to that.
Yeah, so it's very important. Chapter 13 has that strength of the federal government behind it.
How do I pay, how does the trustee get paid?
The trustee in a Chapter 13,
Yes.
they get a percentage of every dollar that goes through for an administrative expense.
Well, I
about
mean,
5%.
how do I pay him or her my, what my plan is? Where does it come from? Do I send in a check? Does it come out of my wages?
Well, the best way to do it if you're gainfully employed is to have it directly come out of your check as a payroll control order. If you don't have that ability,
Well,
if you're self-employed on
Well, then my
Social Security,
employer's going to know, right?
your employer is going to know, yes, yes. But they can't discriminate based on the filing of a Chapter 13. You have every legal right to file a 13, and the Bankruptcy Code says you cannot be discriminated. So if they fire you because of a bankruptcy, you got a separate lawsuit now.
Is that lawsuit going to be protected? Do I have to pay that back into the...
Yeah, the lawsuit's protected. In all my years of doing this, I have not had any client discriminated against, thankfully, based upon the fact that they availed themselves of their federal right to file a Chapter 13 or a 7.
Okay, well, Dave, in terms of chapter, it depends. Hey, it seems like there's hey, Chapter 7 could be right for some people, Chapter 13 right for somebody else. The whole idea is to get people back on their feet, right, so they don't have to worry about all this tremendous pressure.
Right. The best thing to do is just meet with an attorney who's experienced in bankruptcy. Don't go to somebody who does a bankruptcy every once in a while. Go to someone who does it day in and day out. It's become a boutique niche industry, so it's very particular. The laws are crafted in a certain way. There's a lot of time frames and potholes that you can fall into if you don't know what you're doing. Talk with the attorney and be 100% honest with regard to your assets. Because the worst thing that can happen is you file a Chapter 7 thinking you're going to get a fresh start, and guess what? The trustee discovers an asset that you didn't disclose. So not only are you going to lose that asset, but you might be subject to a bankruptcy crime.
Sounds pretty harsh, but hey, if you try to defraud them, that's where you're at. Lastly, what things can I keep? Can I keep all my stuff in a Chapter 13?
Yes, Chapter 13, you maintain all of your property. If you want to keep your house, you can do it. If you want to keep your car, you can do it. You can also decide to surrender the car inside your plan.
And
So
will that
it's very
then
important.
turn to a unsecured creditor after that?
Absolutely.
So it would only be based 10 to whatever percent, depend upon the plan, that I have to pay that creditor back.
You got it. Good to see you, Jesse.
You too, Dave. Till
Great
next
talking
time.
about bankruptcy. We'll see you next time on Legal Action. Take care.